Business organizations, partnerships and limited partnerships. A partnership is an association of two or more to carry on as co-owners a business for profit. Key features are community of interests and sharing of profits. Partners, the owners, share with each other the profits or losses of the business. As all partners are agents for each other, the arrangement follows the theme of all for one, one for all. Each partner is liable for the other partner's torts and liabilities, when acting within the scope of the partnership. A partnership differs from an agency arrangement in that agency does not involve co-ownership or profit sharing. The law governing partnerships in the US is essentially state-based, combining statutory law with common law. There's no federal law governing partnerships, but Title 26 of the Federal US Code provides the taxation framework for partnerships across the country and is instrumental in defining the governance of partnerships in all states. The Uniform Partnership Act, UPA, now in revised form, as well as the original and Uniform Limited Partnership Act, promulgated by the National Conference of Commissioners on Uniform State Laws, sets best practices and encourages uniformity. They're not binding on the states, but the UPA was adopted by almost all the states. The newer RUPA has been adopted by about half the states, so roughly half adhere to the UPA and half adhere to the RUPA. The key advantage for a partnership over a corporation is pass-through taxation. The partnership is not taxed separately from its individual partners. Another advantage is ease of formation. As we will see, there are no formalities necessary for forming and operating a partnership. As the partners are personally held liable, the partnership arrangement is appealing to some lenders. Liability is, however, a significant disadvantage to the partners. If the partnership becomes insolvent, partners are personally liable to pay the partnership debts. All partners are liable for all debts of the partnership. Although partnerships can be easily formed, the partnership agreement can be very complex and burdensome to create. It's often easier to create a corporation where the rights and duties of stakeholders can be easily defined. Adding and removing shareholders to a corporation is very straightforward, but departing partners can be problematic for a partnership, often causing the partnership to be dissolved. Many today believe the disadvantages outweigh the advantages and partnerships are in steep decline. Now that LLCs offer pass-through taxation combined with limited liability, many former partnerships have been converted to LLCs. All partners are jointly and severally liable for the partnership. Liability is not limited as it is with a corporation or other popular forms of business organizations. The partner is personally liable for the debts of the partnership. There are some exceptions and considerations. A partner is liable only for torts committed by another partner when the tort is within the scope of the partnership business. So a doctor partner in a medical partnership is liable to pay for medical malpractice of his doctor partner, but he is not liable to pay for injuries caused in a car crash by his negligent partner when the crash was outside the scope of the partnership's medical practice. The partnership is liable first, then the partners themselves. So the individual partners are not held liable until the partnership itself is unable to pay. The partnership is obligated to indemnify its partners. If an individual partner is forced to pay for a debt for the partnership, the partner can recover the monies paid from the partnership. Under the revised Uniform Partnership Act, RUPA, a permit allowing limited liability for a partner can be filed with the Secretary of State that's binding on third parties. so the liability of a partner can be limited under the modern RUPA guidelines. Traditional common law did not recognize the partnership as a distinct legal person. It treated a partnership merely as an aggregation of the individual partners. Now, under the revised Uniform Partnership Act, the RUPA, the partnership is treated as a distinct entity. The partnership can sue and be sued in its own name in RUPA states and the federal courts. In some states, however, the partnership can be sued, but it cannot sue in its own name. The lawsuit has to be brought by the individual partners. The partnership can own its own property. Property acquired by a partnership is property of the partnership and not of the individual partners. A creditor of a partner must treat the partnership distinct from the partner. The creditor cannot claim property of a partnership to settle the debt of a partner. A partner is an agent for the partnership and has apparent authority to bind the partnership to matters within the ordinary scope of the partnership's business. There is an exception where a third party is aware that the partner has no such authority. The agency doesn't really exist without authority for the agent partner to bind the principal partnership. Under the revised Uniform Partnership Act, the RUPA, the scope of the partner's authority can be defined by a public filing with the Secretary of State. The agency relationship holds the partnership liable for the wrongful acts of partners committed within the scope of the partnership business or with authority from the partnership. Partnerships can be formed by agreement and by operation of law. When formed by agreement, the partnership is created through contracts between the partners. As they're contractual, this requires consent by all the partners and capacity to contract. A child can act as an agent, but cannot form a partnership as she lacks contractual capacity. The statute of frauds applies to all contracts, including partnerships, so a writing is necessary if the partnership is created for a duration exceeding 1 year, or the partnership is formed to transact real estate. Estate filing is necessary to form a corporation, but is not necessary to form a partnership. The formalities are minimal. Unlike a corporation, no board meetings or minutes are required. When testing whether a partnership exists, the courts look for profit sharing. If the parties agree to share profits, then a partnership is presumed to have been created. Whether or not property is owned by two individuals in joint ownership is mostly irrelevant and does not determine whether a partnership exists. A partnership can be created by operation of law. The courts can find a partnership exists even in situations where the partners fail to form a contract or to consent. For example, if an individual holds himself out to a third party as a partner, the individual can be liable to the third party like a partner. The partnership was effectively created by operation of law. A partner in a partnership has a right to participate in management, to vote, access the books and records, and most importantly, a right to share the profits. The right to vote and share profits are subject to management agreement. With the rights come certain fiduciary duties. A partner owes a duty of care and a duty of loyalty to his partners. The duty of loyalty creates a restriction on self-dealing. There's a famous case where a partner independently and secretly negotiated the acquisition of a hotel's leasehold reversion for himself instead of acting for the partnership. The court found the partner had breached his duty of loyalty, so he was held liable to his partner. Business opportunities belong to the business, not to the individual partners. The partnership agreement defines how the partners share the profits or losses and share control. A partnership agreement is not necessary, but recommended to avoid disputes between partners. Default rules supplied by the state apply when no partnership agreement exists. Depending on the state, the rules usually derive from the Uniform Partnership Act or the revised version of the Uniform Partnership Act, the RUPA. Under these default rules, all partners have equal power and all have equal share of the profits, regardless of how much each person has invested and what share each one owns. The sharing of powers and profits can be completely customized in the partnership agreement. There's broad scope for creativity in how the partnership is organized, and these agreements can be lengthy and elaborate. Under the UPA and the RUPA, the default rule is that adding a new partner requires approval of all the existing partners. These default rules can be displaced by provisions on a partnership agreement. New partners can be added without the consent of all existing partners if the process for adding new partners is defined otherwise in the partnership agreement. The incoming partner is liable only for obligations the partnership incurs after the partner joined. Of course, the default rule can be displaced by agreement, and a partner can voluntarily assume liability for past partnership debts and obligations. A partner's share of the partnership depends on the partnership agreement. If there is no agreement, the default rule under both the UPA and the RUPA is that each partner has equal ownership and control. Under the default rule, the partner's financial interest is freely transferable, but management rights are not. A partner can transfer or sell his financial interest in the partnership, but must retain his management rights. He cannot sell his vote. Under the default rules, a departing partner takes his share of the partnership with him. Many states have a compulsory buyout provision for a departing partner. This can render the partnership unstable by providing an incentive for partners to leave an unprofitable partnership. When the partnership is in the red, a partner is not obligated to contribute to partnership losses until his withdrawal or liquidation of the partnership. Removal of a partner involves either a mandatory buyout of the departing partner or dissolution of the partnership. The UPA and RUPA treat departing partners differently. Under the UPA, a partner's departure dissolves the old partnership and forms a new partnership with the remaining partners. The revised Act prefers to retain the partnership and requires a mandatory buyout of the departing partner, leaving the old partnership in place. The retiring partner is liable for obligations up to the retirement, and new obligations where the creditor has no knowledge of the retirement. The continuing partners customarily indemnify the retiring partner for partnership liabilities following his departure. Wrongful removal of a partner gives rise to a claim for damages. Upon a partner's death, his ownership share goes to the other partners, not to his estate. A partnership can survive dissociation, the departure of a partner, but is terminated in dissolution. The UPA favoured dissolution, but the RUPA generally attempts to continue the partnership and prefers dissociation. Dissolution involves selling the assets and distributing the cash to the partners. In a famous case of two brothers in partnership owning 2 mills, instead of giving 1 mill to one brother and 1 mill to the second brother, they were forced to sell both and share the cash. One brother objected to the division of the mills, and in the absence of a partnership agreement, the UPA controlled, forcing the partnership to be liquidated and the family mills sold. When it comes to liquidating the assets of a partnership, client relationships are not considered assets. Limited partnerships. limiting liability for limited partners, otherwise known as investors. Where there's only one class of partner in a regular partnership, and all are fully liable for the obligations of the partnership, in a limited partnership there are two classes of partners. General partners are equivalent to the partners in a regular partnership and carry full liability. Limited partners, however, are not involved in the management, and their liability exposure is limited, usually to the funds they invest. There's limited liability for limited partners, but full liability for general partners. Limiting liability exposure allows partnerships to attract investors, like a corporation, and has been a popular form of business organization for many years. In fact, limited partnerships were equivalent to corporations in ancient Rome, often comprising numerous limited partner investors, some with interests that could be publicly traded like shares in corporations today. Whereas regular partnerships are creatures of common law, limited partnerships are created by statute in the United States. Each state has its own statutory regulations governing the formation and operation of limited partnerships. But the revised Uniform Limited Partnership Act, the RULPA, has been adopted by almost all the states. Any gaps in the RULPA are filled with provisions from the UPA, the Uniform Partnership Act, as the limited partnership shares common ancestry with the regular partnership. The basic rules governing limited partnerships are quite simple. There must be at least one general partner. This partner is liable for the obligations of the whole partnership. The limited partner, LP, cannot participate in management or control, is usually a passive investor. It's not necessary that the partner be an individual. General and limited partners can be natural persons, people, but they can be corporations or other business associations. There are no restrictions on the number of limited and general partners. Some can grow into large organizations. Profits and losses pass through to the partners, and the limited partnership does not pay separate taxes. The trade name cannot carry the LP's name, but must include limited partnership, so that third parties dealing with the business understand the structure. Unlike a regular partnership, a limited partnership must be registered with the Secretary of State. This involves a certificate listing all the general partners and signed by all the general partners. It's not necessary to list all the limited partners. A partnership agreement is recommended that defines ownership and control, the adding of new partners, removal of existing partners, etc. It's not necessary that the partnership agreement is registered with the Secretary of State, only the certificate. The advantages of a limited partnership are: no tax at the partnership level, pass-through taxes avoid double taxation. Limited liability allows the investors to invest without burdening them with full liability. The full liability of managing general partners is often appealing to investors looking to join as limited partners. Full liability is, however, unappealing to general partners themselves, and this is one of the disadvantages of this structure. Another disadvantage is that partnership interests are not as easy to trade and assign as are shares in a corporation.